hectares of what used to be East Mau and rendering it to be a settlement was a valid gazette notice, and he directed the Ministry of Interior, he directed the Ministry of Lands to ensure that those people who were settled there were vetted as required by the regulations. Those who don't have titles, those who are allotted parcels of land but were yet to get title, are also vetted and given titles within 12 months. 5 months later, we want to thank the government of Kenya because it has engaged, it has consulted, and it has finally established a multi-agency team that incorporates the Ministry of Environment, the Ministry of Lands, the Ministry of Interior and National Administration, National Environment and Management Authority, as well as other government agencies. We want to thank the government for moving to implement the judgment, for obeying the court order, and ensuring that the people of Kenya who settled in East Mau in 35,301 hectares had their dignity restored, had their right to life respected, and also had their right to have this judgment implemented respected. However, we've learned this week that one Jackson Olechuta, that is the Deputy County Commissioner Molo, in conjunction with the officer commanding police station Marishoni, have been doing meetings with a section of people in Marashoni who are opposed to this judgment, and to that extent they have resolved from what the clients have instructed us that they will not respect the committees which have been established across the villages in East Mau, particularly in Marashoni ward, and that they would establish their own committees and would move forward to have the judgment implemented on such terms as they like through the committees that would be unpicked by the Deputy County Commissioner Jackson Olechuta. And we've given him, together with the OCS Marashoni, a succinct warning that there are no two ways about it, that they do not have two options. There is only one option, and the option is to enforce the judgment of 30th September 2024, which has not been appealed against by the government. And if they are minded on frustrating the judgment, if they are minded on demonstrating impartiality and going out of their way to divide, going out of their way to take sides in a dispute in favor of parties who do not like the judgment, and ensuring that this judgment is not enforced, we are going to take stern action. We are going to file contempt proceedings in court and ensure that Jackson Olechuta and the OCS Marashoni are punished for disobedience of court orders, what we call in law contumelious actions against valid court orders. And we've given them a warning this day. We have served them with very clear warning that if they don't respect the judgment, and not only respect but ensure that they enforce, because they belong to the Ministry of Interior and National Administration, we shall not only cite them for contempt, but we shall also be moving their superiors to transfer them and remove them from service, where you are not expected to respect the rule of law and constitutionalism under Article 10 of the Constitution of Kenya. And we want to ask any other administrator, any other overseer's administration, that there was George Natembea who attempted to evict the people in the year 2020 from the same parcels of land, and the court very strongly disagreed with him. The DCC, Molo, Jackson Olechuta, you have to learn from your friend Natembea, who failed that time. He should not allow himself to fail this time the way Natembea failed, by attempting to evict people without a valid court order, by disrespecting a valid gazette notice, by trying to disrespect valid titles issued to people, and going out of his way to act in a brazen manner so as to attempt to evict people without nothing. It can't happen in the present day Kenya. It cannot happen tomorrow. It's not happening today. It will not happen any other day. As a country, we have chosen to respect the Constitution, to respect the law, and to respect court orders. And the DCC, Molo Jackson Olechuta, and his friend, the OCS Marashoni, have had it very clear. This is a very clear warning to them that they must respect the judgment of 30th September 2024 by implementing it and respecting committees which have been elected by the villages, who have been picked legitimately and by popular mandate of the people, so that they ensure that if there are going to be any disputes on the ground, they are resolved within record time, because we only have 7 months to the 12 months which have been given by the judgment of Justice John Mutungi, and we remain very grateful to Justice John Mutungi for resolving a conundrum, a problem, a crisis which had been bedeviling the people of East Mau and Nakuru County for more than 2 decades. 8th of September 2024, when the judgment was rendered by Justice John Mutungi, relevant government departments have met. Upon meeting, a multi-agency team has been established with representatives from the Ministry of Lands, with the representation from the Ministry of Environment, with representatives from the Ministry of Interior and Coordination of National Government, with a representative from NEMA, representatives from National Land Commission, and on the same vein, settlers of East Mau settlement scheme, that is Teret, Sururu, Neswet, Likia, Marashoni, have since elected their committees. We have committees at the village level. We also have committees at the sub-location, at the locational level, and in the 4 constituencies. Some might say that they've been taken through the judgment. The government agency, that is the multi-agency team, as well as the committees, have understood what is contained in the judgment. And tomorrow, that is on the 13th of February 2025, there is going to be a meeting between the multi-agency team, which has various government ministries, representatives, and government constitutional institutions and statutory institutions like NEMA and National Land Commission, meeting in Nakuru with a view to moving the implementation to the next stage. I am aware, as a participant in this process and as lawyer for the petitioners and interested parties and the settlers, that tomorrow there shall be deliberations on when to pick the beacons in the registry index map of 2001 in accordance to the legal notice number 142 of 8th of October 2001. So there's been a lot of preparation. A team has been constituted at the government level. The settlers have also established committees, and tomorrow there is a meeting now that is going to signal commencement of the actual implementation on the ground. And as lawyers for the petitioners and the interested parties and Kenyans, we want to say thank you to the government for moving with some element of speed to bring all the parties together and moving to ensure that there is commencement of the actual implementation of the judgment of Justice John Mutungi of 30th September 2024. We remain very optimistic that every implementation, that is picking the beacons, establishment of physical boundaries, vetting of the settlers, and issuance of titles, as well as commencement of the action of environmental conservation, that is putting in place mechanisms to plant 30% of these parcels of land so as to incorporate trees, would be done under 12 months, though the judgment had said trees, 30% of these parcels of land should be planted with trees within 5 years. I see a situation where the settlers, with the support of the multi-agency team, are going to comply within 12 months. This is going to be good for our environment. This is going to be good for the Republic of Kenya. This is also going to be good for the people, because they would have had their titles and would have had closure on the oppression that they have faced for the last 2 decades.
Mm-hmm.